Dear conference participants, colleagues, and friends, I'm very excited to open the annual forum of the Association of Young Legal Historians and to welcome you all to Tel Aviv University, the Bachman Faculty of Law. Allow me to begin by presenting some numbers. Following this year's call for papers, we received over 100 abstracts. Choosing only 65 papers was not an easy task by all means. These papers were sorted to 17 different panels, accompanied by 3 keynote speeches. Our 90 presenters, panel moderators, and other guests are from more than 20 different countries and from 4 different continents. We are very proud to be the ones holding the AYLH annual forum outside of Europe for the first time. Holding a conference that big cannot be done without the help of many people. I wish to take a moment to thank some of them on behalf of the organizing committee. We thank our Dean, Professor Rein, who will be joining us tomorrow, for believing in the success of this conference. We also thank many faculty members that supported us and helped us and gave us very good advice. We especially thank the administrative staff, which are not here, of course, they're doing the hard work, of the law faculty of the conference. To mention but a few, Yerben, Aya, Dalit, Sefi, Michal, Dani, Eti, Varda, Moshe, Yossi, Tali, and Yael, and many more. We really couldn't have done all of this without them. And we really thank you, for our guests from Israel and from abroad, for taking part in this exciting event. I hope we will be able to fulfill all your expectations. We definitely did our best. I think we did succeed with the weather. That's all. I wish you all a very enjoyable and fulfilling and enriching 3 days. And thank you all. Really. I would like to invite Professor Raanan, the Vice President of Tel Aviv University.
Shalom, good morning. I take great pleasure in welcoming you all to the 21st Annual Forum of Young Legal Historians. Tel Aviv University is the largest and most comprehensive university in Israel. It's based on 9 different faculties. You are now at our Faculty of Law, or if you like, our law school, which is undoubtedly the best law school in Israel. And we are especially proud of our group of legal historians led by the dean of this law school, Professor Ron Harris, and the keynote speakers of this event. Tel Aviv University is also the #1 international university in Israel as far as degree programs taught in English, all sorts of international research collaborations. And this kind of conferences, organized mostly but not only by graduate students, is precisely the kind of events that we would like to promote on our campus. I think that you are the next generation of leading scholars as far as legal history is concerned, and this is precisely the place where discussions about different issues that you raise in your papers should be held. Tel Aviv University is also very proud of the diverse student body it has. Among our students, you will find people of different religious background, ethnic background. And because of this reason, it is especially important for us to emphasize values like tolerance, pluralism, and solidarity. As you may all know, we are in the midst of an election campaign in Israel now. And unfortunately, too many politicians at different levels use xenophobic discourse, racist discourse. And our role as a leading research institution is also to play a kind of a compass role in Israeli society. We are in the midst of our own Kulturkampf, cultural struggles over our collective identity. And universities has to play a role not only by producing fine research. So in a way, many of the issues that you discuss here contribute, on the one hand, to the promotion of research, but also to diversity, tolerance, and solidarity. I would like to thank the organizing committee. I think that you've done a superb job, each one of you, and I wish you fruitful and productive discussions. Thank you very much.
I would like to invite Dr. David Schorr, who is the head of the Berg Institute for Law and History and the chair of the organizing committee for this conference.
Good morning. On behalf of the David Berg Institute for Law and History and the Bookman Faculty of Law at Tel Aviv University, I would like to welcome you to the 21st Annual Forum of the AYLH, which is also our 6th Annual International Conference of the Berg Institute for Law and History. I can't say how pleased we are to be able to host such an august assembly of up-and-coming legal historians from such a wide variety of countries and institutions of higher learning. As some of you may know, Israelis are particularly interested in legal history, and our law school with the Berg Institute is both a local and world leader in the field. Nearly half of our faculty members are active in legal history scholarship. We have many graduate students in the field, some of whom are sitting here, an impressive record of publications, of course, and with the support of the Yigal, our known law firm, we have hosted a highly successful law and history workshop for many years in which we bring scholars from all around the world to discuss their papers with us. And the Berg Institute, which I recently took over as head of, is active in supporting all this and many other activities, including one that I urge you to experience for yourself while you're here in these next few days. Down the hall there in our law library, we have an exhibition on the history of the Judicial Committee of the Privy Council, which was, well, it still is, I guess, the highest court for the British Empire. So please take a look at that while you're here. And we also, I should point out, welcome visiting fellows and visiting researchers, and you can find out more about those. I think there's a page in your folder, but also on our website. The website of the Berg Institute has more information on that. Now, our passion for legal history may seem ironic to some. When some of my American friends hear how involved we are with legal history, they often laugh, scoffing that a country less than 70 years old can't have much of a legal history. Now, many of you from Asia and from Europe probably think something similar about American legal history. So that doesn't worry me too much, but it seems particularly appropriate for a young university in a young country to be hosting a conference of young legal historians, and so we're very happy about that. But the truth is that Israel's legal history is much longer and deeper than the state's 67-year history might suggest. We count as our legal history not only the history of the state of Israel, but also the legal histories of the British and Ottoman empires that ruled here, the histories of Europe, East, West, and Central, and the Middle East that have been influential on our legal norms and our legal culture, and the histories of Jewish and Islamic law legal systems that continue to play important roles in Israel today. Our legal history is thus world-spanningly wide and thousands of years deep, so that our 18 legal historian faculty members seem hardly enough to scratch the surface of the legal history that has yet to be uncovered. And that's another reason we're glad to be hosting you here today. We hope this visit will help build strong and lasting relationships among you all and also with us so that you will become part of our wider legal history community. Our three keynote speakers at this conference offer three very different and interesting perspectives on legal history. And I would like to now introduce our first keynote speaker, Professor Shai Lavi. Professor Lavi teaches here in the law school, and he's also the head of the Interdepartmental Safra Center for Ethics, as well as co-director of the Minerva Center for the Interdisciplinary Study of the End of Life. And he's the author of the prize-winning book, The Modern Art of Dying, A History of Euthanasia in the United States. His work and his talk today, entitled The Bleeding Cut, Jews, Muslims, and Animal Slaughter in German History, exemplifies the broad span of our legal histories to which I referred before. So please give Shai your undivided attention.
Good morning, everyone. I'd like to thank the organizers of the conference. It's wonderful to see you today. And thank you, David. It's, my topic for today is the bleeding cut, Jews, Muslims, and ritual slaughter in Germany. I feel like preaching to the converted, talking about Europe to the Europeans, but I hope I'll be able to offer kind of, well, not exactly Israeli, but a Jewish perspective on some of these questions. So my point of departure is the growing presence of Muslims in Europe today, and you're all familiar with many of the questions, debates, conflicts that this has given rise to, from circumcision to headscarf to the cartoon debate, and what I'll be focusing on is the animal slaughter. So what can a legal historian add to this, to these questions? So one way, and the way I'd like to offer today, is to examine this present Muslim questions in light of Jewish history. And vice versa, as someone interested in Jewish history, to ask what does it mean to tell the story of Jewish history in Europe, and specifically in Germany, where the endpoint is not the Holocaust, but rather the presence of Muslims today in Germany, so quite a different kind of history. So the trick is, of course, to choose a question that can actually bring together the Jewish past and the Muslim history and the Muslim present, that would allow to ask whether the Muslims today are the Jews of yesterday, whether the Muslims in the late 20th and 21st century in Germany have anything resemblance with the Jews in 19th century Europe. So the question of the animal slaughter, the Schächtfrage, is exactly an appropriate way of framing these questions, because obviously the ritual itself is shared, and as I'll show you, has given rise to similar questions over 150, 200 years ago, when the focus was on the Jewish practice and not on the Muslim, although as we will see, these are not altogether separate questions. So basically, just to give you a heads up on the way this is going to go, there are two lines of arguments in the paper. One is asking whether the appropriate construction of the problem is as a tension between Muslim minority or religious minorities and the secular state, and I'll be arguing that the secular state needs to be understood not only as a secular state, but through its history as also a Christian or a secularized Christian state. And so what we'll be looking at is an ecology of the Jew, the Christian, and the Muslim. And the second point is that rather than simply discussing this in terms of inclusion and exclusion, the exclusion of Muslims or the exclusion of Jews, I'd like to complicate this inclusion-exclusion matrix and show different models of this formation in this ecology. And partly my talk will be based on research that I've been working on, trying to write 200 history of the animal slaughter debate in Germany. Today I won't be talking about the Holocaust, so it's only going to be the 19th century discussion and the more contemporary discussion. Okay, here goes. In 1982, a German meat producing company applied to the local authorities of North Rhine-Westphalia, at the time a state in West Germany, for an exemption from stunning animals prior to slaughter. So the background is, of course, that with the rise of animal protection societies in the 19th century, animal slaughter, traditional animal slaughter, the neck cut, was seen as cruel, and there was a requirement to stun the animal by a hit on the head or electrocution prior to its slaughter, and this was against practices of both Jews and Muslims. So now this company is appealing for an exemption. The law made the stunning of warm-blooded animals mandatory as part of a general concern with the prevention of cruelty to animals. The company based its claim on freedom of religion, arguing that some of its clients were Muslim Turks who were prohibited to consume the meat of animals that were stunned prior to slaughter. The company further argued that denying such a right would violate the principle of equal treatment, Gleichbehandlungsgebot, since Jews in North Rhine-Westphalia have long been granted such an exemption. In its decision from October 5, 1983, the administrative court at Gelsenkirchen denied the appeal. The court rejected the allegations of unequal treatment, basing its decision on the following grounds. Quote, "The permission for Jews to slaughter represents an act of political, cultural, and humanitarian compensation to the Jews who are still alive, den noch lebenden Juden. The Jewish religion has in Germany a greater historical tradition than the Muslims. Jews have integrated more or less into the German people, Volk, as Germans, with essentially the same rights and duties. There exists no violation against the principle of equal treatment with respect to Muslims." This is a candid confession, some would say tactless, of the kind that can hardly be found in verdicts of higher courts, and thus requires a more painstaking effort of researching decisions made by lower courts in the periphery. As we shall see, higher courts in Germany found different and more subtle ways to justify the very same discrimination of Muslims, which lasted several decades. The lower court grounded its decision on the aftermath of the Holocaust and on the cultural integration of Jews in Europe, that is, on the so-called Judeo-Christian bond. According to some historians, the Judeo-Christian bond became a popular trope in post-World War II Europe as a response to the Holocaust, but had the consequence and at times the intention of singling out Muslims as a new minority in Europe. The case suggests a simple pattern of inclusion and exclusion, inclusion of Jews and exclusion of Muslims. While this has become a common model in present-day Europe, history suggests the existence of more complex patterns. Okay. So now a look back into history. The first opponents of the Jewish-Muslim ritual were Christian pietists, revivalist movement in 18th and 19th century Germany. In the early 19th century, long before the question of animal slaughter made its way into the legal arena, German pietists objected to ritual slaughter not only because it was cruel to animals, but also because it manifests a distorted understanding of religion. According to the German pietists, Jews and Muslims practiced ritual slaughter in order to avoid the consumption of blood, which they mistakenly identified as the soul of the animal and its life power. This was a superstitious belief because the soul of the animal was obviously not in its blood, and consuming animal blood cannot have the effect on human spirit. The drawing out of animal blood cannot have true religious or moral significance, the pietists argued. It only prolonged the process of dying and consequently the suffering of the animal. So there is ground for this understanding of animal slaughter in Judaism, but the emphasis that the pietists give it has obviously an Orientalist connotation. The pietists believe that true religion is based on inner conviction and on the work of the heart. Christians, too, the pietists argued, have laws governing the relationship of animals to animals, and yet as opposed to Jews and Muslims, quote, "The practice of this law and its scope are hard to determine by external laws and will therefore be delimited by the voice of one's own conscience and duty." The pietists did not only criticize Jews and Muslims for morally mistreating animals, they were also echoing Kant's critique of Judaism and Islam, which based the religions on external ritualistic practices rather than on internal moral spiritual commitments. The expectations from 19th century German Jews and 20th century German Muslims was that they would adjust their religion to the norm of the secular state, which was nothing other than the secularized Christian state. Indeed, Jewish law, and specifically the dietary code, became a central indicator of the abilities of Jews to become part of modern German society ever since Christian Wilhelm von Dom's famous 1781 treatise concerning the amelioration of the civil status of the Jews. In its 1887 petition to the Reichstag, and now this is already moving into the legal arena and the first attempt to ban Jewish slaughter in Germany, the National Association of Animal Protection argued that, quote, even religious views are not unchangeable, but must conform to the progress standards of humanity and education. Similarly, and now comparing with the present, Roland Koch, the premier of the German state of Hessen, stirred public controversy when he demanded in 2008 that, quote, the integration of foreigners will only work if there are clear rules for living together. Whoever breaks these rules of the game must reckon with the consequences, end quote. Using as one of his prime examples ritual slaughter, he criticized Muslims for slaughtering animals in the private homes, quote, in residential areas with a high number of immigrants, there must be clear laws of the game. The slaughter of animals in the kitchen runs counter to our principles, end of quote. Thus, the first model of inclusion-exclusion was exclusion of both Jews and Muslim practices from a secular, or rather Christian secular state. The second model, which we have already mentioned in the opening case, is that of the Judeo-Christian bond. That is, the inclusion of Jews and the exclusion of Muslims. Contrary to prevailing scholarship, however, this model predates the Holocaust and, at least in Germany, concerns yet another religious minority, the Catholics, who were a very large minority in the predominant Protestant Kaiserreich. The debate concerning the Jewish animal slaughter made its way to the Reichstag during the last decade of the 19th century. A combination of animal protection advocates and anti-Semites introduced a bill that would require pre-slaughter stunning and thus effectively ban Jewish animal slaughter. This was a convenient timing for the Jews. The divisive and bitter Kulturkampf, Raanan just mentioned this in another context, which Bismarck initiated against the Catholic Church, had come to an end only a decade earlier with the understanding that freedom of religion must be respected in Germany. Thus, there is little surprise that in the early debates at the Reichstag, the strongest support of the Jewish ritual came from the Catholic-based Central Party. The support of Jewish slaughter in the name of tolerance is indeed quite expected. Perhaps less expected is Windhorst, the leader of the Central Party, additional justification of the practice. Quote, I have looked into the matter and I am convinced that the Orthodox Jews will take a great offense at this proposal, and so they must do, because the proposal stands in conflict with the views which they have had since youth, views which originate out of Mosaic times, which we too have experienced in the first days of Christianity, since we can indeed be confident that the early Christians still observed the aforementioned command. End of quote. Here we see how the Jewish practice is accepted on the basis of the affinity between Judaism and Catholicism, or more generally, the Judeo-Christian bond. This affinity is twofold. First, Judaism, like Catholicism, is a religion practiced by a minority of German citizens who deserve legal protection. Second, Judaism shares its historical origins with Christianity. Christianity is, in some sense at least, a progressive version of Judaism. Comparison of Jews and Catholics, though present in other publications from the time, were not always taken for granted. A critical stance appeared in a Berliner magazine for slaughterhouse profession. The author rejects the comparison of Jewish ritual with Catholic profession of faith due to the inhumaneness of the former. The Jewish custom should rather be equated with the Muslims, who are known for their cruelty to animals. Quote, supporters of the ritual, the author concluded, occupy the same cultural level as adherents of the Quran. And I'm less interested in the pejorative sense of this, but more in the way that Muslim or Islam is present in Germany and in the German discussion prior to the actual presence of Muslims in Germany, or at least in numbers. Back to the present. The differentiation between Jews and Muslims continued in the 1980s and well into the 1990s. While the lower court in Gelsenkirchen based its decision on an explicit reference to the Judeo-Christian shared values from which Muslims were excluded, higher courts justified the restrictions of halal slaughter in more novel and subtler ways. In a series of cases which made their way from local administrative courts in late 1980s to the Federal Administrative Court in 1995, courts distinguished between Jews and Muslims on different grounds. First, the court argued that for Muslims as opposed to Jews, ritual slaughter was not binding. While the court did not deny that Muslims were accustomed to practice ritual in their countries of origin, they argued that such practices were merely a custom with no binding force. Courts could make this argument in good conscience, both because the exact procedures of ritual slaughter are not explicated in the Quran, and because the prohibition on stunning of animals prior to their slaughter is disputed among Muslim scholars. Second, some courts based their decision, that is, the distinction between Jews and Muslims, on the fact that many of the Muslims in Germany at the time were of Turkish descent, and many continued to be Turkish nationals. The German courts turned to Muslim authorities in Turkey and in other countries of origin, asking for their legal advice on the matter, so to the official Islamic authorities in Turkey, for example. In their response, the Muslim authorities either approved stunning altogether or claimed that Muslims living in non-Muslim countries could be more lenient than the countries with predominant Muslim population, and that Muslims in Germany could practice pre-slaughter stunning. The courts decided to downplay the fact that the appellant Muslims who were living in Germany, often for more than a generation, developed their own religious positions and wished to fulfill the entire scope of their religious duties in what they gradually began seeing as their home. Third, and finally, in this line of argumentation, the Federal Administrative Court held that religious exemption could not be rewarded on individual basis and required the legal recognition of the Muslim community as a Körperschaft des öffentliches Recht, a corporate body under public law. Only once a religious community is recognized by the state will it be able to claim the traditional slaughter as obligatory for its members. The decision implied that Muslims would be prohibited from performing the ritual, since Muslims, in contrast to the Christian and Jewish communities, have not been publicly recognized. Characteristic of this line of cases, all three arguments, was an appeal to legalistic terms that allowed to distinguish between Jews and Muslims. The court identified Judaism and Islam, and this is an important point, as legalistic religions, and applied to them the framework of legal positivism, a jurisprudential mindset which in principle was alien to both religions, but at that point in time accommodated Jews better than Muslims. Under this framework of legal positivism, a law is obligatory only if it is written, which the Jews could prove and the Muslims could not, and only if it was posited by a well-identified state-sanctioned authority. Jewish practice, however, was privileged because Jews adapted to the Christian Protestant model. Now it's important, and I won't go into this, that in the 19th century, Jews faced exactly the same challenges and were much harder to prove their eligibility for an exemption. Okay. The discrimination against Jews and Muslim practice of ritual slaughter were not limited to official state regulation and were often a matter of private law, litigation, and law in action as opposed to law on the books. The practice of legal officials was more readily influenced by popular public images of ritual slaughter. These images linked animal slaughter with common accusations leveled against Jewish and Muslim violence. Anti-Semitic and Islamophobic publications associated the practice of slaughter with existing stereotypes in the 19th century of Jews and in the 20th century of Muslim violence, implying that adherents to a religion that commands the ritualistic and cruel slaughter of animals are prone to even more extreme and deliberate brutality. This, too, was a modern reincarnation of some old Christian tropes. A relatively mild instance of such allegation appeared in an 1896 article titled "Meat for the Goyim" in the anti-Semitic newspaper General Anzeiger. The article tells of two instances in which Jewish butchers defiled meat sold to Christians, one by spitting on the meat, the other by infecting it with flea. The article, which builds on familiar accusations concerning the unhygienic character of Jewish slaughter, takes the charges one step further by claiming that Jews purposefully seek to harm their patrons. The article introduces into the modern anti-Semitic discourse anti-Jewish libels that were common in Middle Ages and could still be found in the Hebraistic literature that is in 16th, 17th century, early modern period. Though anti-Semitic defamation is characteristically distinguished from traditional Jewish hatred due to its scientific basis, anti-Semites did not hesitate to turn to old libels when they wished to attack Judaism as a religion. The venomous article would have soon been forgotten if not for a lawsuit initiated against its author and the journal editor by the Jewish Central Association, the Zentralverein, as part of the latter's new strategy against anti-Semitism. They were charged for creating public nuisance due to their unfounded and undistinguished condemnation of the Jewish community as a whole. To their great disappointment of the Zentralverein, the courts acquitted both defendants, claiming first that since publications were targeted to an anti-Semitic audience, they did not affect the public at large, and second, even more damagingly, that it was not unreasonable to suggest that Jewish law encourages the defilement of meat. More extreme was the link that anti-Semites created between the Jewish ritual slaughter and blood libel. Here too, we face the reemergence of medieval European slander in turn of 20th century Germany. The blood libels, which accused Jews of killing Christian children and using their blood for ritual, were commonly directed at the Jewish slaughterer, who, according to the allegations, had both the thirst for blood as well as a technical knowledge of cutting meat. Indeed, the Jews who were accused in two of the most renowned cases of blood libel in 1891 in Xanten and in 1900 in Konitz were Jewish slaughterers. The violence attributed to Jews stigmatized modern Jews by vilifying their traditional customs. It is characteristic of the stereotypical image of the Jews that the danger he brings about took place behind closed doors. The depiction of Jewish violence as sinister and uncanny played a special role by the late 19th century when many Jews no longer appeared outwardly different from Christians and, like the violence associated with them, were hard to detect. The Jews posed a threat from within which could easily be guised, and precisely for that reason was so dangerous. The images of violence associated with the Muslim ritual have been quite different. While Jewish violence was characterized as a hidden betrayal, the violence currently associated with Islam has a character of an open war, and that too has historical origins. Muslim ritual slaughter has been commonly linked with the threat of political violence and terror. Implicit association can be found even in the mainstream Der Spiegel, which in a special edition under the title Allah in the West, Islam and the Germans reported, quote, "In the autumn of 2004, Mohammed Bouhari, the son of a Moroccan immigrant who was born in Amsterdam and attended school there, slit Van Gogh's throat as if he were slaughtering an animal on an Amsterdam street." End of quote. A few lines later, the journal adds, "In a number of cases dealing with halal butchering, German courts were forced to grant exceptions to Muslims butchers similar to those applied to butchers who adhere to Jewish kosher butchering rituals. In 2002, the Federal Constitutional Court issued a landmark decision allowing butchering according to Muslim ritual after Rüsten Altenküpe, a butcher in the eastern city of Wetzlar, had filed a lawsuit." And this is kind of associating terror with animal slaughter. Okay, I'm going to skip this. In the case of the Muslims too, the association of animal slaughter and political violence has gone beyond the public stereotype and media representations. After the 2002 Constitutional Court decision to grant Muslims the right to equal rights, to the Jew, local municipalities continued to mount obstacles on the Muslim practice. They required Muslim butchers to submit detailed lists of clientele in order to limit ritual slaughter to the necessary minimum. Most Muslim butchers have found it difficult to find clients that would be willing to submit their names to the authorities. Representatives of Muslim organizations, whom I personally interviewed, have claimed that community members fear that their names will be passed down to public officials who would use the names of for surveillance purposes in the so-called war against terror. This has been especially true of members of the Miligurush, a religious group who has been put under the surveillance of the German secret services, the Verfassungsschutz, due to its undemocratic agenda and whose members are often more strict in their observance of Islamic law in general and dietary laws in particular. If the anxieties of members of these Islamist groups have any truth to them, and I think they do, then the consumption of traditionally slaughtered meat has become an indicator for criminal and violent risk. Okay. Muslim violence, unlike the Jews, is associated with political violence and the public spectacle of violence. Muslims are not perceived as more violent than Jews, but only exhibiting different forms of violence. The violence associated with Jews in the 19th century operated in the shadows, the alleged violence operated in the shadows, whereas the violence associated with Muslims appear in daylight as a clear threat. So this is more like Jews as strangers from within and Muslims as strangers from without. So time to conclude. Divided by a century, both Jewish and Muslim struggles to carry out their traditional practices took place on national level and local level in courts and through different levels of regulation, and drew the attention not only of animal protecting societies and religious communities, but of the public at large. This history cannot be reduced to simple patterns of inclusion and exclusion. At times, Jews were welcomed into German society due to their growing affinity with mainstream German Christian culture, and Muslims were discriminated against as foreigners who do not belong to the Jewish Christian tradition. Other times, both groups were conceived as strangers, but Jews were feared as strangers from inside, whereas Muslims were feared as strangers from outside. But in other contexts and on different occasions, a much more complex picture emerged. The German public and legal system has strived to welcome Muslims to the extent they were willing to be good Muslims, and the Jews to the extent they were willing to adapt and be good Jews. The present debate on animal slaughter and similar debates on male circumcision can benefit from historical analysis, not only because history is always interesting and allows us perspective on current events, but also because this history is still alive everywhere in Germany including, and in other European countries, which are no doubt secular, but whose secularism bears the historical marks of history and specifically of secularized Christianity. Though my paper focuses on discrimination and different forms of inclusion and exclusion, I wish to end on a positive note. In 2002, and I've already mentioned this, in passing, the German Constitutional Court decided to grant Muslims the same rights as the legal system has granted the Jews. Though the problem has not been settled and local administration continues to pile difficulties, there is room for optimism. In addition, the struggle of animal slaughter has created unexpected partnership between Jews and Muslims, which is an interesting story for another day. To tease your imagination, I will conclude with a short paragraph from a book by Zafer Janakok, a Turkish-born German author, retelling his own experience as a young immigrant boy in Germany. It was the first winter after our arrival in Germany. Anton was visiting me. "Where's your Christmas tree?" he asked, standing in our living room. I asked my mother where our Christmas tree was. My mother asked my father where our Christmas tree was. My father asked God above about the Christmas tree. God above despaired. Sometimes I went shopping with my parents. We took the tram into town. I loved the blue trams, which had their own peculiar smell, which gave me headaches. A highlight of these trips was a visit to the butcher. Butcher shops have always fascinated me. Nowhere else can one see so much blood and raw meat. Our butcher was a friendly, elderly man with a calm, gentle face. He had the usual physical proportions of a butcher. Sometimes he wore a small skull cap, slightly smaller than the one my father owned. The visit to the butcher always involved conversation which I did not understand. The butcher wasn't alone in the shop. An ancient man with a long beard was often sitting on the chair in a corner. The gray beard probably made him older than he was. He spoke to my father about God, and I didn't understand what God was doing in the butcher's shop. My father called the man with the beard a chacham, Hebrew for sage. He was happy to see him there. "We can be sure that the meat here is clean," he said. Thank you.
Thank you very much. It was very enlightening. A few quick administrative announcements before we go up. And we will go up now to the third floor where all panels will be conducted today and tomorrow. Coffee breaks as well will be on the third floor. Please know that all panels, including the keynote panels, are filmed. And it will be uploaded to the Berg website. So if you don't want your presentation to be filmed, just tell us or the moderators. Just tell us or the moderators and all the filming crew. Lunch will be served here on this floor at 1:30. At about 4:20. We will gather near the steps that is just outside the faculty building, and we will go together from there to the buses that will take us to Tel Aviv. We will have a very festive reception at the Beta Ir, at the old city hall, and we'll have two alternative walking tours in Tel Aviv. If you have not picked your tour, just find our administrative staff and tell them to which one you want to join. And then we'll have a dinner at Meganda restaurant. And that's all I have for you now. I thank you all again for coming here and for listening to this first panel. I invite Omer. And I'm sorry, I invite David and Omer.